Before we take a break here and get into our first topic, I just want to introduce the topic and our first guest. There was an interesting news story that I saw that brings up some interesting issues of legality and religion. It's a fascinating story out of Oregon. A woman is suing the Church of the Latter-day Saints because a clergyman had reported her husband to authorities after her husband made a confession that he had sexually abused a child. So the parishioner went to his clergyman, said he had sexually abused a child. That was part of his religion, to confess to that crime. And the clergyman reported him to authorities, and he now is serving 15 years in prison. The wife brought a lawsuit seeking over $9 million in loss of income and emotional distress, saying the clergyman and the church should never have reported that because of the confidentiality that a clergyman has with his parishioners. And here to discuss this very interesting issue is James Bell. James Bell is a fabulous attorney. He's got a national practice in Texas, New York, and California, where he represents individuals and companies in criminal and civil matters, and he's won over $6 billion in verdicts for his client. Welcome to the show, Jim. How are you?
I'm well. How are you?
Good. We only have a minute before we have to take a break, but this is a fascinating story. Can you tell us a little bit more about the nature of what this guy did and how he came to confess to his clergyman?
Sure, yeah. I mean, obviously, he had an inappropriate, illegal relationship and sexually assaulted somebody, went to the clergy person and confessed, just like you said. And, it raises an interesting issue about privileges, which you know all about. I mean, the clergy privilege between a parishioner and a priest or a pastor versus, somebody's duty to report wrongful or illegal conduct. And therein lies the issue. I mean, what is more important is whether or not the privilege ought to prevail and confessing something where there's an expectation of privacy, or reporting a heinous crime.
Jim,
and that's really what's at issue.
And that's what we're going to talk about in the next segment. If you have any questions, 981-7200. Otherwise, stay tuned. We'll be talking more about this fascinating case on the Karen Conti Show on WGN. We're talking to Jim Bell, who is an attorney, and we're talking about this fascinating case out of Oregon, where a woman is suing the church because her husband confessed to a crime, and the clergyman turned around and reported him to authorities, and he's now serving time, and she's bringing a lawsuit for lost income, loss of companionship, and for emotional distress. Can you talk a little bit, Jim, about what the nature of the privilege is when it comes to talking to your clergy? What does that actually mean?
Sure. Under Federal Rule 506, the person that confesses or speaks to their clergy person about some kind of act that they had committed in the past. We're not talking about a future act, but we're talking about an act that occurred in the past. That person has a right, and the clergyman has a right, but the person that makes the confession has a right to prevent the clergyman from passing along or reiterating what the confession was about. And so in this instance, it appears that the clergyman violated the duty to remain, to maintain the privilege. It's akin to the attorney-client privilege. If it's the client or the parishioner in this instance that holds the right to the privilege, and in this instance, it doesn't sound as if the parishioner gave consent to waive the privilege, and rather the clergyman acted ultra vires or outside the scope and went ahead and passed along the confession, which would be in violation of the federal rule. And the question is whether or not it's tainted.
Okay, so let's just make this simple for our listeners who are not attorneys here. But I just want to talk a little bit about the privilege and the reasons for it. And I assume that the privilege is, if I am a person who did something wrong, the law should protect me when I do what I think is right from a religious standpoint, which may mean that I go to a Catholic church or I go to my Baptist church and I tell somebody there to unburden myself and to seek, some sort of, whatever it is that you seek in a church, depending upon your religion, and that should be sacred. And that the clergyman should not use that against you, if you will. Is that am I stating that correctly?
That's absolutely correct. Yes.
So in this case, when the clergyman did this, and here's my question, because in Illinois, we have laws we call mandatory reporter laws, which means that if you're a nurse, if you're a teacher, if you're somebody who deals with children, say, and you see bruises or you hear something that is sexual abuse, you have an obligation legally to report it to the police. Otherwise, you could be in trouble yourself. Was this what the clergyman here thought he had to do?
The answer is I don't know. I would be speculating on what his state of mind is, but I think you raise an interesting point. But having said that, I think there's a difference with the distinction. With respect to teachers and folks that work for the state, they have an obligation, like you said, but it goes back to separation of church and state. In this instance, it's somebody from the church who is in a position to give advice and give counsel and issues. And I'm not condoning the underlying behavior, obviously, but the the clergyman is in a position to help deal with the parishioner and help move him in the right direction and maybe get him to confess, because that's the right thing to do. But I don't think the clergyman in this instance had the right to, since it didn't concern a future act, it concerned an act in the past, didn't have the right to basically violate his parishioners' confidence.
And, if put yourself in that situation, just all legalities aside, we as lawyers think like lawyers and speak in terms of rules. But, when you hear something like that, an underage child is being violated, and you hope it's not going to happen again. But we all know that those types of crimes, they can happen again with somebody who is predisposed to it, not making any assumptions in this case. But you would be in a very hard place to try to do the right thing, to try to bring justice to the situation and maybe prevent it in the future. But on the other hand, you have a duty to your parishioner to listen and to forgive and to do what you're supposed to do under your religious code. So it's just a real hard legal issue here.
I agree with you 100%. I mean, if it's the case that clergymen and priests, et cetera, are going to take matters into their own hands as it relates to their parishioners and their confessions, then maybe they ought to think about putting up a big red and white sign and say, don't confess your sins, because we can go to the state or to the federal government and turn you in.
I mean, that's a good point. That's a very good point. So maybe it puts everybody on notice. I mean, everybody's familiar with the attorney-client privilege. You go in, you talk to an attorney, you talked about some kind of past conduct. The attorney has an obligation to keep that sacrosanct and keep it confidential. I believe the same. It's a similar privilege to that of somebody with a clergyman, that you go in, you're confessing your sins, and you expect it to remain confidential despite subpoena powers from the state or the federal government, and that you're on safe ground. But if that's not the case, maybe they ought to put their parishioners on notice that you can no longer come in and confess your sins, because you run the risk that we're gonna report it to the government, and we're going to testify against you. I want to remind my listeners here, this was a national news story, but it was a local, huge news story. The case of Drew Peterson, everyone here is going to remember it. He was accused of killing his second wife and was suspected of killing his third wife, and then was accused of trying to assassinate our state's attorney in Will County, ex-police officer. But it was interesting in that case is that the third wife had gone to her clergy clergyman and had said, I saw Drew Peterson with bloody clothes that night, and he put them in the washer, and he talked about killing her. And so the clergyman at the trial testified as to what Stacy said, and the courts ruled that didn't apply. The clergy privilege did not apply for one reason or another. I think partly because Stacy was dead and it wasn't being used against her. But that was a front and center issue in a very big case that we had here. And you do see these situations. They do come up. It's not as rare as one would think. But why don't we just talk just briefly about the attorney-client privilege? Because I get this question all the time. And Jim, you practice both in state and federal court and both in civil and criminal court. And sometimes people will say to you, should I tell my lawyer that I did it? And my lawyer can't disclose it, but what happens now if I tell my lawyer? Am I better off telling my lawyer or just keeping my mouth shut? What do you think?
As a general proposition, if I were to give advice to a client that was going to go to another lawyer, I would tell. I think any lawyer is not going to ask, as a general, especially in a criminal case, going to ask whether or not the client did it. The lawyer's job is to put the state or the government to meet their burden of proof, which is beyond a reasonable doubt. And I mean, there's an argument to be had whereby if the client confesses and says and obviously it depends on the circumstances, and I understand that there's kind of a spectrum here, but it puts the lawyer, especially if the client wants to defend the case all the way, it puts the lawyer in the position if the lawyer finds out about whether or not they're going to work as hard or they're going to try and examine every single aspect of the case to show reasonable doubt. And obviously if the client consents, then I think there could be potentially a subconscious sabotage on the part of the lawyer where he's not going to look for the kind of reasonable doubt because deep down inside he knows the client actually committed the crime. In other circumstances, and I don't mean to filibuster here, but in other circumstances whereby the client says, hey, look, I did it. I want to cut the best deal possible. I want to take a plea, admit to what I did. Then in that circumstance is probably okay. But if as a general rule, as a practicing lawyer, I never ask the question whether or not the client actually did it. And usually the client... And that's I think that's a very common thing. And listen, Jim, I'm sorry to cut you off, but we're going to have to take a break here. I want to thank you. I'm going to give out your contact information. It'll be on the website. But thank you for joining my show. This is the Karen Conti Show on WGN.